In this video, we are going to be covering what happens after your first court date in a criminal case. How many court dates are there going to be? What's going to happen with them? What can you expect? My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, this video is going to be about what about all the in-between court dates? After your first court date in a criminal case, what happens there? Now, this is actually part of a series of videos. This is part 2, where we talk about these, what I call check-in dates. And I've actually created a criminal case timeline, which you can find for free down below, that kind of explains what to expect in a criminal case. And I think one of the most confusing parts about it is, okay, so you show up for your first court date, get the police report, they set another date. For what? Right? For what? What's going to happen at the other date? This is a very frequently asked question, and I mean, that question makes a lot of sense. So I explain this to my clients, and it's explained on this timeline here, as these are basically check-in dates. Now, I know that this sounds stupid because if you have a case, really, your attorney and the DA, if we're going to come to some kind of agreement with it, whatever it may be, maybe it's a dismissal, maybe it's some kind of plea deal, maybe it's that we're just going to go fight it out at trial, we should be able to sit down for just a few hours and knock that out, get it done, right? There's not a whole lot to it. For a private criminal defense attorney, yeah, I have time. I can go sit there with them for a few hours, but the DA, remember, has usually between 25 and 50 cases that they're trying to deal with in a single morning. Between court, and they're in court, at least all morning, but many times all afternoon too, or trying to figure out what the heck to do. They have to at least read the file in all of those cases, right? So catching them between court dates can be tricky. Of course, sometimes we can get it done. They'll email. It depends on the DA. It depends on their caseload. It depends on how much they care about getting back to people. But really, the main reason for most of these check-in dates is to meet with them, to talk to them, to be persistent, for them to say, oh, you again with this case. What did you want? Classes in exchange for a dismissal? And eventually, perhaps to say, fine, that's fine. So negotiating with the DA, that is the number one purpose. We're not going to just take the first deal and run. And many times at court, going back and forth with the DA only goes so far. We come back again. Sometimes we get the judge involved, go to chambers, see if we can get the judge to put some pressure on the DA to resolve the case. Another reason for these check-in dates is motions. If we want to file a motion, if we want something from the court, maybe we want a private investigator appointed. That only applies to LA County. Orange County, not going to do it. Riverside, no. But maybe we want a private investigator. Maybe we want a psychological evaluation for free done for our client. Maybe we file a motion to suppress evidence. Maybe there was a confession and you weren't read your rights. All of those motions require one of these dates. So at the first court date, we may not even know what kind of motions we want to file, but unless we have a check-in date set, there's no time to have that motion. So we need to have those check-in dates. Another reason is discovery check-ins. Okay, so this is one of the things that I thought was the craziest and was one of the most surprising to me when I started doing criminal defense. So let's say that the prosecution has accused you of murder. They've set your bail at $1 million. You go to your first court date and the prosecutor hands your defense attorney, how long is this, 5 pages? A police report that's 5 pages long and says, oh, I'll have the next discovery to you, meaning like the rest of their case file. Maybe by the next court date, we're still trying to gather it from the cops. Okay, how can that be the case? They've decided that they have enough evidence to, number 1, arrest you. Number 2, hold you on $1 million of bail. Shouldn't they have like a box? Shouldn't they have it already and just hand it over to your attorney? But the fact is that that is not the case, and there are some protections for that, but most of those protections don't kick in until you're in the trial stage, and you don't necessarily want to get into the trial stage unless your attorney can figure out, should you go to trial or not? What kind of chance do you have? And for that, we need that big box of stuff. So, and this has become kind of an accepted practice, I think, just because the criminal case system is so overburdened, I suppose, or so they say, that it's just accepted practice. But you would think you think they should have it together, but they don't. And so if I just let's say I don't come back every, month or two to the court, and the DA tells me, hey, I'll have this discovery to you within like 2 months. Don't worry, I'll email it to you. We can come back in 3 or 4 months. Do you think he's going to have it to me in 2 months? He won't. The DAs are not generally looking at their files very much unless either they're prepping for trial or there's a court date coming up. That court date is the impetus to get them to actually look at the file and do something. So it is really important that we have these court dates so that they look at the file the night before and they're like, oh shit, I still didn't send Veronica all the discovery I promised her, and then they go ahead and send it to me. And many times that is how it happens. The night before, finally it rolls in. So that is another purpose. And when we go to court, what's going to happen? We're going to say, I just received discovery. Let's set another date so I can look at it and see what else is missing, because probably there's still going to be a lot. The final reason is subpoenas. So let's say that we want to subpoena, for example, the victim's medical records in a case. The subpoena return, so basically the stuff that we ask for, is going to go to the court. But we don't get to open it and look at it unless we have one of these check-in dates. So we want to make sure that we're there, that we have these opportunities to do any number of things that we may need to do in the case, because as much as my clients and I, any criminal defendant and their private criminal defense attorney can meet, can try to move the case forward between court dates, really not a whole lot is going to happen unless we are at court. Which brings me to something else. Many times between court dates, clients, criminal defendants think like, what's the update? What's going on with my case? The truth is, besides what your attorney told you at the last court date is going on, we're waiting for this, we're waiting for that. Or if they told you I'm going to set up a meeting with the DA's supervisor or something like that, or if they're working on a motion, nothing's happening. We just can't, the court will not let us set a court date generally a week down the line. Sometimes we can, but usually we have to wait about 30 days. So the time for things to happen in your case is in general going to be at court. Anyway, I hope that you found this video helpful. Keep in mind, if you want to see, I'm going to be making videos. This is 2 of, I believe, 8. As I'm filming them, you will have videos of each part of this available to you, and you can go ahead and take a look at this document to read it all for yourself. If you do have a case in California that you need help with, feel free to book a call with me down below. You can click on the link, and you can also give me a call. My number is there.